Today's 30th.
Yes. In case of AMU also.
It depends on the nature of the statute.
Yeah, correct.
There are different statutes. There may be a statute which is a curing statute. There may be a statute which is intended to alter the situation on the ground.
Yes.
There may be a statute which recognizes a pre-existing situation. So we can't have a general rule that the moment a statute comes, yes, you are right to this extent, that if it's a statute which is a complete code in itself, then you don't look beyond the statute.
I bow down to it. It was not my submission that as a general proposition, once an enactment comes, the past is evaporated or is extinguished. My respectful submission is that in case wherever an educational institution or for that matter any body corporate is established, the statute takes over. That's
warm. I think we'll
literally and figuratively.
It will become warmer.
Warm enough.
That possibly, my lord, may not be aware.
Yes.
Lord, something before your lordship is assembled, my lord. The past, my lord. Lord, my respectful submission is, this is a pre-constitution statute, and whatever is extinguished cannot be tested on the ground of fundamental rights which came after the constitution. And for which, my lord, I have two illustrations to give.
Yes.
Yes. Lord, even during the British era, pre-constitution era, where the British legislature used to legislate for the purpose of universities, whenever the legislation felt that we must recognize and incorporate the founding events, they have so done. Lord, that illustration I wish to give. Lord, unless, because, my lord, the argument of the petitioner was that while reading the statute, you have to go behind it to know kind of genesis, the word which was used, or that finding moment, the founding moment. No, that is not so. Unless legislation recognizes, the statutes take over from that date, and it is that complete code which governs the future course of action for that university.
Yes.
Lord, my submission is restricted to incorporation of universities, those statutes, my lord, not statutes in general. Please, my lord, allow me to place before your lordships volume 4I, page 535. How the past is statutorily recognized by the British Parliament. 4I, page 535 minutes. But it starts at 538. It is Annamalai University Act. So the purpose is to point out to your lordships and assist that whenever the legislature intended that we must recognize the founding event, they do so by way of a legislative enactment. The parties cannot request the court to go behind it, because behind it there can be two views. I say it was not founded by XYZ. Somebody may say it was found by ABC. Somebody would say it was found by DYF. So therefore, the legislative device in case of incorporation of university pre and post constitution both is this, my lord. Kindly have a look at page 538. Annamalai University, your lordships have.
Yes, we have the act.
My lord, this is Annamalai University Act 1929. So it is a pre-constitution act.
28 or 29?
29. Section. Yes.
Yes.
Lord, please see an act to establish and incorporate a teaching and residential university at Annamalai Nagar. Whereas it is desirable to establish a teaching and residential university for the encouragement of higher education in research in Tamil Nadu districts so and so. Now please mark this, my lord. And whereas the Honorable Diwan Bahadur Sir SRM Annamalai Chettiar has established and is maintaining colleges at and near Chidambaram in which higher instruction is imparted in English, Tamil and Sanskrit studies. And whereas Sir Annamalai Chettiar has agreed with the local government to hand over the said institutions together with all properties attached thereto, and further to give a sum of 20 lakhs of rupees for the purpose of establishing and maintaining at Annamalai a teaching and residential university wherein he and his heirs shall be entitled to certain powers and privileges. But please see 2C. The term founder is defined. Lord, it is at page 539.
Yes.
Founder, 2C. Lord, founder means the Honorable Diwan Bahadur Sir SRM Annamalai Chettiar, and after him his son, Mr. M.A. Muthaiya Chettiar, and for all time after the lives of the said two persons, in respect of every vacancy, any adult male member chosen by the Chancellor from amongst the members of the said Sir Annamalai Chettiar's family, consisting of his other sons and his descendants, tracing their descent through males, and if no such member exists, or if one such exists and he does not consent to act as founder, or if no such member is competent in the opinion of the Chancellor to act as a founder, then and until such a competent member comes into existence, is willing to act, or one who was not competent becomes competent, etc., etc. I am not reading it, but this is how the founder is statutorily recognized. That's the only legislative way the British Parliament used to, my lord, act. Now please come to section 8, my lord. The following shall be the officers of the university, namely the Chancellor,
Yes.
the founder. Rest are not relevant, my lord.
Yes.
And please, my lord, come to section 11 at page 544.
So, Sir Annamalai Chettiar would be the founder for life. He would hold the office of founder for life.
As recognized by the statute
By the
itself.
statute. You got the point.
So, the court in future will never be required to undertake the exercise of going into the genesis of founding moment, etc.
Interestingly, what happened post independence to these statutory provisions?
Lord,
I mean, it's not relevant to your argument, but just as a matter of curiosity.
it was deleted post 2017.
So until 2017, that
17 it
continued.
continued. No, where is that act? No, it's 2013 Act, my lord. That's the amending act, page 1458.
Page
Of the
one.
same, Lord.
145.
145.
Nothing else in this act that you want to show us, right? So otherwise we had
Section 11, my lord.
section 11 we saw.
Yes, 544.
That we saw.
Your Lordships have said. 1458, my Lord, just to answer my Lord's query. We have placed that on record.
That's the 2013 Act.
Yes.
Let's just see it.
My Lord, the entire act is now, a new act has come into force.
Oh, I see.
And there is no, my Lord, founder.
Oh, they brought in a new act in 2013
Yes.
to replace.
So-
So right until 2013, that
That
hereditary,
continues, the member of the Chettiar
hereditary
family.
founder continued in Annamalai University.
And that founding fact and name of the founder was recognized. Whatever he must have bargained with the government, that was also recognized. He would be a member, he would be a part of the term officers. And my Lord, my learned senior my Lord wants me to see short page 12 also, my Lord. I'm sorry, section 12. Please come to my Lord, page
12 of the
Oh, yes,
repeal
sir.
act.
the original act,
Lines of 99.
1929 act, my Lords.
To rise for 2 minutes today at 10:59 because it's Martyrs' Day.
Yeah, yes.
But I heard the siren go off. It's just 10. Anyways, whether the siren goes or not, we'll all rise at 10:59.
No, whenever my Your Lordship rises, we will rise. Lord, section 12. The Vice Chancellor. The Vice Chancellor shall be appointed by the Chancellor from a panel of 3 persons recommended by the founder. This is administrative control also, apart from the fact of establishment. He is not only a member of the term officers,
Persons recommended by the
In pre-independence India, there were statutes which did recognize the role of the founder in establishing the institution, even post the enactment of the legislation by the imperial legislature. That's the point which you're trying to make.
and if he wanted a role in the administration,
Which
also,
is, according to you, absent in the case of the
present
ALIGARH
AMU,
Muslim University.
Lord, similar thing happened, my Lord, with Vishwa Bharati Act. My Lord, I stand corrected. Lord, my instructions are, there was no degrees being given by Vishwa Bharati, Shantiniketan, my Lord. But when the act came into force post-constitution in 1951, my Lord, I could get it, my Lord, during the, my Lord, I have shared it.
They'll upload it on the visualizer. वो upload कर दीजिएगा.
Only one para is to be seen. That there is a statutory device where founding fact, founder member, and what the other side says genesis, is recognized by way of a statutory enactment itself.
What do we find in the Vishwa Bharati Act?
Yes, my Lord, it is. It was founded by Rabindranath Tagore, Thakur. That's mentioned in section 2 itself. Section 2, my Lord, is on the screen. Declaration of Vishwa Bharati as an institution of national importance. First is, this act may be called Vishwa Bharati Act. It shall come into force. I skip. Declaration of Vishwa Bharati as an institution of national importance. Whereas the late Rabindranath Tagore, Thakur, founded an institution known as Vishwa Bharati at Shantiniketan in the district of Birbhum in West Bengal, the objects of which are such as to make the institution one of the national importance, it is hereby declared that institution known as Vishwa Bharati aforesaid is an institution of national importance and is as such hereby constituted as a university. So two things happened. The founding person is statutorily recognized and university is established by an act of parliament. Lord, your Lordships would find it was made university in 61. Otherwise, it was an institution of national importance. The footnote, my Lord, makes it clear. My Lord, I just now got, my Lord, the original constitution. That is my respectful submission. But I have got the constitution of original Vishwabharati, but I got it in the morning only. I will go through it and place it on record. If there is something to be highlighted, I'll request one of my learned senior colleagues to highlight, because my turn would be over. I don't wish to come again. Now, may kindly see. So, my respectful submission is that in absence of this founding event, or what they call genesis, etc.,
if we'll take your submissions that absent a statutory recognition of the founding moment, the statute therefore obliterates the entire past
and takes
begins,
over
and begins on a clean
as
slate.
a complete code. And that is the statutory device adopted by the legislature both pre and post constitution. Volume 4C. But
Solicitor,
my lord,
in the absence of an express obliteration of the past by the statute, can the court not look into the pre-existing history unless we find that there are certain express provisions in the statute? I mean, I'm just putting you the flip side of it so that, to elicit a response. Absent an express obliteration of the past by the statute, is there something in law or constitutional law to prevent the court from looking at the circumstances which led to the creation of that university or the creation of that institution by a statutory provision?
My respectful answer, would be no. The simple reason is, that history always has several shades. Absent Annamalai part, in the act which I have shown. Suppose that would not have been taken care of, or recognized by the statute. There may be 5 versions of history that not Mr. Sir Annamalai, it was Sir Chettiar also who was running. It was not Sir Annamalai, it was somebody else also who contributed money. It was not Sir Annamalai, the entire...
In other words, could it be like this? Could it be your submission, therefore, that unless the statute expressly recognizes the minority character of an institution, you cannot claim the right? Would that be, can we stretch it to that point?
I would not say minority character. I would say for any university, the founding event, founding members, and founding facts, whoever is saying whatever, unless recognized by the statute, if it becomes a statute, the statute is the final word. It would not be possible for any party to request the court to go behind it and try and find out the history.
That's why you have sort of distinguished the case of Annamalai and...
Yes, and that would be so about even majority institutions. I do not know, Annamalai may even be a majority institution.
Annamalai non-property is it's not an Article 13.
No, maybe a linguistic minority, I am not aware of. Maybe a linguistic, may not be a linguistic, but whenever any university incorporated under an act, unless that's, therefore I have shown, and I'll show other university similar examples. All that.
Fair enough, you have made the point. Now
yes.
We can go to the next.
Now your lordship may kindly come to volume 4C, page 1346. Lord, this is debates of the year 1972. Lord, I have a
standard.
Volume 4,
Okay.
reassembly. even if, my lord, history is to be gone into, so there are two sets of histories before your lordships, my lord. I have given a different list of dates and events. The question would be, Lord, how would your lordships examine? I'm posing a question to myself. Which part of the history is true? Therefore, my lord, even from the prudence test, the submission which I am making, that whenever statute recognizes or wants to recognize by a legislative enactment the founding events, Lord, it would be final, and the statute takes over, it becomes a complete code. Now, your lordships may, my lord, kindly allow me to place volume 4C, page 1343, my lord. Lord, this is the speech before the House by Professor S. Narul Hassan, who was the Minister of Education and Social Welfare, in 1972 when amendment was introduced.
Page 1343.
Yes, 1343. Lord, your lordships would recall there was an amendment in 1972 in AMU Act. And I'm just showing, my lord, who is speaking, my lord. The concerned minister, my lord, this is the stand of the government. The Minister of Education, Social Welfare and Culture, Professor S. Narul Hassan. Please, my lord, see second unnumbered page on the right side column. What change was made? Earlier, your lordships are aware. 1343, volume 4C, my lord.
C, okay.
Yes, Lord, I may not take your lordship's time. I'll just orally say.
No, you can just show it to us. We are already on it.
Yes, Lord. Formally, the chancellor was elected by the court. Your lordship knows the court then, in 2020 was consisting of Muslims. We are now proposing the chancellor shall be appointed by the visitor in such a manner as is provided in the statutes. And in the statutes, it is suggested that out of panel of 3 names, the visitor may appoint a chancellor. The chancellor should be able to exercise his moral authority in the best interest of the university and should not in any way be associated with any group or faction. Therefore, he would be above all decisions, because he will not be a party to any of the decisions. So, he is not dependent upon the votes of the court. Now, my lord, more important part is at page 1346. And in my respectful submission, after this, no debate, my lord, from the petitioners can survive in the present matter. This is the stand of the government through the Honorable Education Minister while amending the Act itself. Your lordship, my lord, has page 1346. My lord, right hand side column, last 2 paragraphs. My lord, it starts with it would not like. I would not like. Does your lordship get, my lord? So this is what the government says in parliament, because there were demands that you declare this to be a minority university, and the minister answers, I would not like to take very much more of the time of the house except to refer to 2 or 3 points which have been raised. First of all, a demand was raised that this university should now be declared to be a minority institution in terms of Article 30, Sub-Article 1 of the Constitution. Sir, this is a demand which is neither in the national interest nor in the interest of the university itself. Nor, if I may venture to suggest, of any section of our population, including the Muslim community. The responsibility for the educational development of every section of the population has been taken by the state. Maybe it is some part of it with the union government and the other part is with the state government. If the educational development of the entire country and all sections of the population is to be ensured, it would be necessary to see that the state plays its due part. Any single institution cannot be maintained by the central government for the benefit exclusively of one community or to be run by a single community. Till 72, there was a demand that you declare it to be a minority institution. And for very valid reason, with a foresight, looking at the future, not a very eminent educational minister made this statement that it is not in the interest of the nation, nor in the interest of the community. So, my lord, after this, in my submission, my lord, the issue is closed. That's my respectful submission. My lord, similar, kindly come to debates of 1981, same volume, page 1680.
Same volume?
Yes, my lord, 1680. My lord, this is the bill which, my lord, your lordships may recall, introduced. The word establish was deleted. And definition was added as a post facto approval of one-sided history. Well, I am not going into the merits or demerits of 81, but I wish to read, my lord, what transpired in the parliament. Lord, kindly come to 1680. These are the debates when 81 amendment was introduced. Shri G.M. Banatwala, your lordship said. Mr. Deputy Speaker, sir, the Honorable Minister has been kind enough to tell the House that it was one of the pledges of the ruling party to restore the minority character of Aligarh Muslim University, and this bill seeks to fulfill this pledge. I, on my part, respect the sentiments of the government, but I wish that the provisions incorporated in the bill had really led to fulfillment of the pledge. Mr. Deputy Speaker, sir, the government, as we understand now, wants to restore the minority character of Aligarh Muslim University. But kindly pause here as a factual thing. The government never wanted to restore. It has said in 72 that it cannot be given. Something can be restored if it existed at any point of time. Be that as it may. Then why does it fight shy of saying so in the bill itself? Why should there be reservation? There are certain basic things which need to be understood. We are not playing with words. Those who are not capable of understanding the words are totally incapable of understanding the ideology and the facts behind this. There are showboys who have brought great woes and pains to this country. I have only to tell the government not to practice self-deception. The main issue is the restoration of the minority character to the Aligarh Muslim University in such a manner that the university gets protection of Article 30, Sub-Article 1 of the Constitution. The university has to be recognized as an educational institution as envisaged under Article 30, Sub-Article 1 of the Constitution. I'll skip the quotation. The judgment in Aziz Basha's case is a standing injustice both to the provisions of our Constitution as well as the minority and the secular concept that we have in our country. In this case, the Supreme Court has erroneously made an observation that the university has neither been established by Muslims nor has the administration of the university been ever exclusively vested in the minority in Muslims. Therefore, there are two aspects of the question. Please mark this, madam.
Yes.
He is demanding now that all right, you have established by incorporating the word, by deleting the word establish. You are taken care of according to his understanding, not subject to that act being challenged. Now give us the administration also. So therefore, I am reading it. And the minister says no, administration cannot be given. So even as per this debate, my lord, in parliament, nothing survives. Lord, I am on page 1680, the bottom side top. Therefore, there are two aspects to the question. Your Lordship's get. One aspect is the aspect of establishment of the university. This bill clearly says that it has been established by Muslims. Your Lordship would recall the definition of university is changed. That's what my Lord he is referring to. We are thankful to the government. I congratulate the government that the government has come forward with a recognition of this historical fact. But then the other aspect remains, and that aspect is that since allegedly the administration of the university never exclusively vested amongst the Muslims, therefore it is not an educational institution envisaged under Article 30, sub-Article 1 of the Constitution. He admits that unless I have the administration, I can't rely upon 30 sub-Article 1. The position should therefore be clarified. The definition as given of the term university in the present bill, which is now before the House, does not fully meet the requirements of Article 30 sub-Article 1 of the Constitution and does not fully set at naught the observations of the Supreme Court in Aziz Basha case. Therefore, it is that we have come before the House to clarify explicitly that ALIGARH Muslim University is a minority institution within the meaning of the minority institution under Article 30. Now, directly come to the reply of the Honorable Minister at page 1682 on this question. The request, the demand that administration should also be given to us. It admits there is no administration with us, and the Honorable Minister 1682 right hand side, my Lord, your Lordship get Srimati Sheila Kaul. My Lord, I'm sorry, my Lord, I may just, my Lord, before that, a page before that, my Lord. (1681), my Lord, just right hand side, there was a suggestion to add an explanation.
Right, I saw that actually.
Notwithstanding any judgment, decree, etc., my Lord, which was not accepted by the Parliament. Now, please come to 1682. Srimati Sheila Kaul, my Lord, she was the Education Minister.
No.
The Lord Srimati Sheila Kaul, as an Education Minister, answers on the question of administration. As the university will be administered in accordance with the provisions of the Act, statutes and ordinances, it is not possible to agree to the amendment moved by Shri Banatwala, and the amendments are not therefore acceptable. Lord, the amendment which was moved is, Lord, please see, lobbies have been cleared. The question is to be administered by the Muslims of India. The Lok Sabha divided, my Lord, and this amendment failed.
Can you just show us that little, when Mrs. Kaul moved the bill, what was the purpose? Because when she introduced the bill, she may have clarified why she was moving the bill. Can we just see that part so that
Yes,
since
yes.
otherwise, you know, to go to it later, maybe
Yes,
just.
I'll just, my Lord, in a second.
1154.
154.
No. No, not this one. I'll read this also, but there is some else. I have marked it.
What you asked about to move and what would move. What are the main structure?
So can your Lordships come to 1590? This was, my Lord, thereafter referred to the standing committee.
Just come to 1155.
154 and 55, yeah.
1155.
1155. Lord, shall I?
It is a pledge that we seek.
It is the pledge that we are seeking to redeem today. It was a pledge that we gave to our Muslim brothers. The establishment of ALIGARH Muslim University Act was an important landmark in the development of modern education of Muslim of India. However, it was not the point at which the history of the ALIGARH Muslim University started. As far back as 1870, Sir Syed Ahmed Khan realized that modern education was the only means for removal of backwardness of the Muslim community in India. At his initiative, a committee to devise ways and means for the educational regeneration of Muslims was set up. 2 years later, sir, a society called the Mohammedan Anglo-Oriental College Fund started. Well, then the history. May I read, my lord, history again, my lord? One side history is given, my lord. The second side history, that you started negotiating with the government and started giving up one thing after the other, is not recorded. And countered by Sri Somnath Chatterjee. But if your lordship wishes me to read, I can read, madam.
Just a little bit, we'll just see what
Yes,
you
yes,
were saying.
I'll just read. One of the steps taken by the society was to open a school in 1973. There, 3 years later, sir, it became a high school, and in 1977, the foundation stone for the establishment of a college was laid. Sir Syed Ahmad Khan died in 1880. It should be 1877 and 1873. 1880. But the idea of establishing a university gathered strength even after his death. The Muslim University Foundation Committee had started collecting funds for setting up the university. The MAO College ALIGARH had by that time grown into a leading center to the education of Muslims. After prolonged discussions extending over 6 years between the Government of India and the representative of Muslim University Foundation Committee, the ALIGARH Muslim University Act with Mohammedan Anglo-Oriental College as its nucleus was passed. Well, there the history is not given, that there were continuous correspondence that this is the condition, take it or leave it. This is the condition, take it or leave it. That is not given, my lord. Sir, 1920 enactment was the realization of the long cherished ideals of the Muslims of India, and it was their dream that found expression in the establishment of this university, and a substantial part of the properties and funds which went into making was also contributed by them. Sir, these are the facts of history which we must recognize and acknowledge. For quite some time, the Muslims of India have been expressing concern that the law governing the ALIGARH Muslim University does not recognize or acknowledge these historical facts. Therefore, there has been a unanimous demand voiced by the Muslims of India that the ALIGARH Muslim University as it stands today should make provision for the acknowledgement of this fact. This demand has the support of all sections of the country, including all political parties. Sir, the ALIGARH Muslim University today is one of our largest residential universities. It is a composite institution offering education from the nursery stage to the highest level of research. The courses offered by the university cover all major disciplines: engineering, technology, medicine, science, social science, and humanities. Something I am respectfully basing my submission on this as well. No?
It's clear that the object of the government of the day in introducing this 1981 bill was to recognize, as the Union Minister said, a historical fact that it was established by the Muslims of India. That we can't. That seems to have been the
I
intent
also
of
can
this.
wish away. But before that, she says that this was a part of our election manifesto. And your lordships, I leave it at that. Your lordships may realize the danger if the parliament were to be permitted to recognize 100 years history, hundreds of years of history. I leave it at that, my lord.
That is Parliament's exclusive domain. We can't.
I am happy. I am very happy.
The policy underlying the.
I am very happy. I am very happy. I am arguing only university matters, but Parliament deals with many historical facts. I am very happy.
Subject to constitutional validity, of course.
Of course. But therefore, I didn't want to elaborate much on that.
But what stands out is one of the honorable members, Mr. Banatwala, wanted a clarification to be inserted in the act that this is a minority institution.
Yes.
But there the honorable minister said no, administration would be according to the statutes and the ordinances. Therefore, administration part cannot be left with a particular committee.
Yes, my lord. Coupled with the fact that Mr. Banatwala says that unless you give us administration, we cannot fall under 30.
Only establishment part was so to be recognized, but
Yes.
administration part was refused.
Was categorically refused.
But then when was for the first time the institution was recognized by the government as a minority institution.
This was never recognized.
It's one thing is very clear. The intent behind the 81 amendment was to recognize and give it as a minority institution and to do away with the, whatever the reasoning was given. The attempt was to modify the reasoning given or make the statute, modify the statute so that the reasoning given in Basha's case is not applicable. Yes?
Is this not that?
No,
After half an hour also it rings?
No. No, no.
administration is concerned, yes, Mr. Banatwala did say that please make an amendment saying its administration is with the Muslims. That the government did not agree. But what they said, administration is already provided in the statute. As per the
Statute, the statute, yes, yes.
No, all statutes will provide for administration. Even today, even after the 2004 Act, the Education Act, minority, each statute will provide for administration. That's not the administration, the word, mainly because the statute provides for administration is not cannot lead to a finding whether it's a minority or a majority
No,
institution.
Lord, I would risk.
That will, if we accept that argument, that if administration is provided by the statute, then this itself is going to be a ground to decide whether its institution is a minority or majority or non-minority institution, will lead to difficulty.
I'll just, my Lord, respectfully, my Lord,
How
answer.
can that be? Mainly because administration is provided by the statute. That is not, may not be the criteria.
Kindly.
We have to find out who are the people actually administering it,
Correct.
or in terms of the statute, who are the people entitled to.
I bow down, my Lord. Your Lordships will have to examine the statute as it stood in 1981, and in that context, my Lord, examine the request of Mr. Banatwala that right now it is not our administration, and therefore we are unable to fall within the second part of Article 30, Sub-Article 1. That establishment, yes, but not administered by us. You clarify that we are administering also. She says no. Act will govern.
Whether,
And the amendment.
whether the government was right or not, that's a separate issue. But the fact of the matter is, the government also, when they were saying it's a minority institution, they very well knew of the requirements of Article 31. They felt that the administration is also with the minority.
No, my Lord.
Because otherwise they will not say it's a minority institution.
No, my Lord, they didn't. I'm sorry.
Mr. Solicitor, they were very well aware the two requirements for minority institution, establish and administer.
Correct, my Lord.
To say that when they moved the amendment and made an open statement in the House of the Parliament saying it's a minority institution, they were not aware that administer is also one of the requirements, will be little difficult to accept. Maybe they may be right or wrong, it's a separate question.
Yes, my Lord, maybe they consciously, my Lord, did that. All right, we satisfy you. We recognize the historical fact. What they have done is recognizing the historical fact according to their history, without, my Lord, or rather omitting the history which I have shown. That one after the other, they started, my Lord, giving up their rights. If there was no concept of a right, but their demands, their insistence, that this we will not accept, all right, we give up. This we will not accept, all right, we give up. That's not taken care of. But they say that we recognize a fact in history that this is what happened. As my Lord, I'll not reread it. But everyone was clear, including the government. But especially Mr. Banatwala, that unless you give it, and what was, my Lord, the amendment suggested? Amendment was administration to be given to Muslims. That was within inverted comma. And the minister says, no, it will be as per the Act. If as per the Act, your Lordship finds that it was Muslim administration, that's a separate thing. But if that is so...
Solicitor, to really conceptualize your argument, because I think we've heard you on this, your argument is that Article 30 incorporates twin tests, establishment and administration. Basha came to the conclusion that, well, one, ALIGARH Muslim University was not established by Muslims, though it does recognize the history of Anglo-Oriental College, etc., because it says it was established by statute. That's the first limb of Bhasha. And inasmuch as that it was established by statute, it has not been established by a Muslim minority. That's the first limb of Bhasha. Second, Bhasha says on the review of the Act that it is not administered by the Muslim minority. The 1981 amendment, according to you, was intended to recognize the historical fact of the establishment of ALIGARH Muslim University and brought about that change both in terms of the preamble and in terms of the definition of the expression university. But the second limb of Bhasha, which was that it has to be administered by the minority, there was no alteration to the existing statutory provisions in relation to administration, and which was in fact noticed by Mr. Banatwala that you cannot, in that sense, though he didn't put it in that word, in those words, that you cannot override Bhasha unless you deal with both the establishment and the administration tests. And you had left the administration intact, and therefore it would not, in that sense, still fall within the ambit of 30.
Bhasha still stands, good stand.
And
That's what he.
That's your contention.
And my lord, I'll just add
And
one.
perhaps,
thing.
therefore, your contention is that the 1981 Act did not take away the basis of Bhasha, because you could have taken away the basis of Bhasha by not merely
Establishment,
recognizing,
but
but administration as well. That's your
Plus-
submission.
plus,
We'll have to
Lord-
hear the other side in response. I think now we've understood it conceptually.
Another
That's what the
aspect.
other
Lord,
hard
Bhasha
issue is here.
Bhasha also recognizes.
I think that
the-
is really the submission.
Yes, Bhasha also recognizes the fact that your rights, if at all there were any pre-constitution, were extinguished, because you started giving up those demands one after the other, and therefore there was no concept of a minority or minority rights in 1920. It was just a bargain between me and the government. Some of them, my lord, said that we will not accept your bargain. We will say that no, we want to have this framework. But those who were in charge, my lord, Mr. Sefi and led by them, my lord, they say, all right, we give up this, we give up this. Government says no, it would be full control of the government. All right, let it be government control, etc. My lord, I have given. Bhasha recognizes that. My lord, the parliamentary debate does not.
All right. Anything now?
Lord, next, my lord, next. Please come to page, volume 2A. I'll take only 10 minutes, my lord. 2B, I'm sorry, 2B. At page 50 to 54. I'm not going to read, but I just want to give, my lord, the illustrations.
Please, Mr. Solicitor.
50, my lord.
2B,
2,
page 50 to
554. How, my lord, this factum of founding or factum of establishing is always recognized whenever the legislature wants to recognize by the legislature itself, and how it is recognized. Even administration is recognized by statute. Therefore, I say 1920, the curtain falls, the statute takes over. Lord, please see, Sam Higginbottom University of Agriculture. My lord, it is, my lord, University for Anglo-Indians. Please see, my lord, the title. At page 551, my lords. Volume 2B, page 51. The lordship gets, my lord. I'll just, my lord, the small font, my lord. This is, my lord, the preamble of the Act. An Act to establish and incorporate a teaching, research and extension university with a view to upgrade and reconstitute the existing Sam Higginbottom Institute of Agriculture, Technology and Sciences, deemed to be University Allahabad, established and administered by the Ecumenical Minority Christian Society, namely so and so. This is how, my lord, establishment, the historical fact of establishment and administration is statutorily recognized. Please see, my lord, same at the foot of the page, same university, the jurisdiction, save as otherwise provided. I'm sorry. Because the argument of other side was on a wrong reading of Bhasha that all these universities will go as minority institutions. No, it will not go. Legislation has conferred upon it the minority character. Please see the jurisdiction. Jurisdiction of the university, save as otherwise provided by or under this act, the limits of the area within which the university shall exercise its powers shall be whole of Uttar Pradesh with its headquarters at Allahabad, with powers to associate any Christian minority institution within its jurisdiction. The predominant purpose of minority character of the institution is statutorily recognized. My lord, kindly come to page 52. ERA University, Lucknow.
Page
52, next page, my lords. ERA University, Lucknow. My lord, the other side would say that these were institutions incorporated after the National Minority Commission Act. That is true. But wherever the legislature has thought fit to record the historical fact and give it a statutory color, they have provided. So that's my purpose. And this is, my lord, in response to their submission that if Bhasha is right, that once you are incorporated, you can never be a minority institution. That reading of Bhasha is wrong. Bhasha does not say so. Bhasha is only a sui generis, fact-specific judgment examining the ALIGARH Muslim University. Please come to B, the ERA University, Lucknow. An act to establish and incorporate a teaching university sponsored by ERA Educational Trust, duly established and administered by the members of Muslim minority community. Then, my lord, trust is also accordingly defined. I will not, my lord, take your lordship's time. Please come to next page. In all these acts, my lord, the power, not only statutory historical fact of founding is recorded, accepted statutorily, administration is given. Please see, my lord, Tirthankar Mahavir University. An act to establish an act to establish and incorporate, I'm sorry, madam.
Yes.
An act to establish and incorporate a Jain minority teaching university sponsored by Tirthankar Mahavir Institute of Management and Technology Society, Moradabad, Uttar Pradesh. The 9 also, Lord, kindly see only the highlight, underline part. Nothing in this section shall be deemed to prevent the university from making appropriate provisions for reservation of persons belonging to minority community in the post and recruitment of the employees and reservation of seats for admission in any course of study in the university which cannot exceed more than 50%. Lord, I am not duplicating, but the same provision in Northeast Adventist University. This is, my lord, a Christian minority institute, university, established by an act. Then, my lord, please come, my lord, only last example, my lord, I would like to give. 4I, my lord, volume 4I. I'm on Alia University, page 1375.
Same volume, 1375.
No, 4I. Same volume, 1375. 4-5.
7-5.
My lord, 1375, yes.
This is 4I.
4I. ALIGARH University, my lord.
Volume 4I.
Yeah, 4I.
Page,
Volume 4I.
page
1375.
1375.
75.
Thank you.
This is a West Bengal legislature, my lords. Your lordship would have the title West Bengal Act of 2007, my lords. Please see, my lord, the preamble. The second part, whereas. Does your lordship get, my lord? Whereas it is expedient to upgrade Calcutta Madrasa College, erstwhile Madrasa ALIGARH, one of the oldest institutions of higher learning and culture in India, and to that end, to establish and incorporate a teaching university at Kolkata, to dissolve Calcutta Madrasa College, a government madrasa college, and to transfer to and vest in the said university all properties and rights of the said college. Now please see, my lord, 3.3. 1378, my lord. Section 3, subsection 3. 1378. Lordship gets, my lord. But please see, this is important, very important, my lord. Whenever the legislature wants, legislature does this. 3, subsection 3. The character of the university shall be same as that of Calcutta Madrasa College, erstwhile Madrasa ALIGARH, declared as such with a minorities development and welfare of Madrasa Education Department, Government of West Bengal notification and dated so and so. Statutorily provided, historical fact recorded, and the same status and character statutorily recognized. Now, my lord, I come to my last argument. But please come to what is this university, my lord? Volume 2A. I'm sorry, 2B, my lord. Page 12.
Page?
12. And my lord, I would, this is my last submission, but very important submission, my lord. I take only 10 to 15 minutes and then, my lord, I am done. Lord, what would be the, well, there are two things I want to highlight. A, why this issue arose and we are before your lordships. And 2, see the consequences if your lordships were to interfere and your lordships are not in appeal against Basha. What would be the consequence of an institution which the Constituent Assembly declared to be a institution of national importance? Please come to, my lord, page 12. Just broadly, what this university is about. This is one of the finest university of the country, my lords. Lord, it has, my lord, total, my lord, I have given, my lord, the chart, total number of entities, then number of faculties. Please see faculties, my lord. Agricultural science, management studies, arts, engineering and technology, theology, medicine, social science, life science, Unani medicine, law, science, international studies, etc., etc., etc. My lord, large number of, my lord, subjects, my lord, are being taught. Please come to, Lord, I will not read everything. Please come to page 15, number of colleges. There are 8 colleges affiliated. And the next is number of centers. They have centers, my lord, all over the countries. But I am not right now addressing your lordships on that because that's not the question. But TMFI says, for the purpose of deciding minority, the unit is state. Muslims are not minority in Kashmir. What would happen, my lord, if they have a learning center in Kashmir? That's not, my lord, the right now, my lord, question, and therefore I am reserving that argument. Please see number of centers, my lord. They have 23 centers all across the country. Then number of academies, they have 3 academies. Number of institutes, number of schools, and the number of students, my lord. Please come to para 16, page 16, bottom. How many students are studying? 27,619. Correct, my lord? It does not include polytechnic students because they are getting diplomas. These are all degree holders. Now, why this problem arose? Lord, please take the Constitution of India, my lord, for a while. Article 15. My lord, I need not highlight that equality is heart, soul, and blood of the Constitution of India. After, my lord, we became free from the British regime. Article 15, my lord. Your lordship gets it. 15 sub-article 1. The state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Lord, nobody can be discriminated against. Hindus, Muslims, Sikhs, everyone are at par. Now, earlier, an argument used to be raised that there is an exception to this under sub-article 5, which is not accepted. Lord, your lordships have said that sub-article 5 is not an exception, but another facet of equality. Because the government, the nation, the country wanted scheduled caste, scheduled tribes, socially and educationally backward classes also to be at par, and therefore sub-article 5, my lord, was introduced. Nothing in this article or in subclause G of clause 1 of article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or scheduled tribes, insofar as such special provision relate to their admission to educational institutions, including private educational institutions, where aided or whether aided or unaided by the state. Please underline this, my lord. Other than the minority educational institutions referred to in clause 1, article 30. Meaning thereby, your lordships have the mandate of equality under article 15, sub-article 1. Another facet of equality for scheduled caste, scheduled tribes, and socially and educationally backward classes. And the last part of sub-article 5 is an exception to that equality clause. And therefore, your lordship's test to decide whether a particular institute or university is a minority will have to be a very strict test. Lord, this amendment is after TMFI and PA Inamdar. They do not take note of this fact, my lord. Where your lordships have said that 15.5 is an extension of the doctrine of equality, because scheduled caste, scheduled tribe, SCBCs, they are not equals. They are required to be brought at par with rest of the citizens, irrespective of the religion. But exception is minority is accepted, meaning thereby, and this is, my lord, crucial.
Doesn't this then amendment also accept the reasoning given in TMA 5 that the minorities are entitled to have reservation in their institutions?
Aided institutions. Yes, it does say.
Doesn't it then give that recognition?
Yes. But my lord, the question is, now, if Aligarh Muslim University, having these many faculties, law, commerce, medicine, engineering, this, that, and others, and one of the finest university recognized as a national importance, institution of national importance by the constitution at the original framing of the constitution, would not have reservation for SC, ST, and socially, economically backward classes. And they would have at least 50% reservation for Muslim candidates. So, a deserving candidate of a scheduled caste or a scheduled tribe or a socially and educationally backward class person would not have the reservation, but an Lord, person having all Lord, economic, everything Lord, at his command, based on religion, would have Lord, reservation, and that led to filing of petitions before the Allahabad High Court. Lord, that is what I wanted to show. Lord, please come to volume 3E, page 20. Page 19, I'm sorry, not 20. Volume 3E. My lord, your lordships would also examine from the point of view of social justice and equality. One interprets
that choice was made by the Constitution, right? When they brought in the 93rd Amendment.
I'm saying taste would be very rigorous. That's all I'm saying.
They introduced it. This was a constitutional policy now, which is given
This
for
was
us.
challenged.
And if you have an Article 30 institution, you are accepted from the provisions
Correct.
of
Correct.
all these provisions.
My lord, my respect, I'm not saying that your lordships may decide the horse that exception. I am saying that 15.1 is equality clause, 15.5 is extended equality clause, and the last part of 15.5 is an
Excludes minorities.
exception. Therefore, your lordship taste, the taste which my lords would adopt, would be very, very strict taste, because it would be SC, ST, SEBCs, or Muslims, or any linguistic minority, or any other minority. So social justice, my lord, would be a very, very determining factor in your lordship's decision making. That's my respectful submission.
All right. Yes. Anything else, Mr. Sultan?
My lord, only 5 minutes. My lord, why, my lord, this came? My lord, why the petitions came? They introduced in PG Medical College this reservation. Page 34, my lord, this is directly.
Which volume are you referring?
Page 34, my lord, volume 3E, 3 capital E. This is
Yes, Mr. Solicitor.
Lord, please come to page 34
Of
volume 3E. This reservation came in 2005. That led to filing of petitions. And your lordships would, my lord, bear in mind, it's almost an admitted position between the parties that even without a reservation, approximately 70 to 80% students are Muslims. I'm not on religion. It's a very, very serious phenomenon. An institution of national importance declared by the Constitution must reflect, my lord, the national structure. Without reservation, this is the position.
And across the board in all universities.
Correct, my lord. It is happening. All universities have students from every walk of life.
Yeah,
Please
do
see,
we
my lord,
have-
now 34.
Do we have the data with regard to that?
All national institutions, IITs, my lord.
No,
I can place it on record. IITs, IIMs, all institutions of national importance.
please place that up, record.
I undertake to do that.
Place it up.
Because they do not provide for any reservation.
No, we are not, there is no question of reservation because that's barred under Article 15 and that's.
Maybe the atmosphere they have given to the institution, IIM, for example, anybody would go. But I do not know, but
Just get us the.
we would get it. I'll need 2 or 3 days, but we
may
would.
not be able to get it for a lot of institutes, but maybe institutes of substantial.
Prime institutes, definitely will be. Page 115, I have given of 2B. Please come. Just institutions of national importance. Your lordships may perhaps not require the figures. 2B. But I undertake to give it. 2B, page 115.
Volume 2B,
Volume 2B.
page 115.
5. They all have people, students from all spectrums of life. Please see, my lord, ALIGARH, Banaras, we leave, University of Delhi. Then Atal Bihari Vajpayee, Indian Institute of Information Technology and Management, Indian Institute of Information Technology. Then, my lord, please come to the next page. All IITs.
How many institutes have you listed under this?
In this list, my lord, the total number is 165.
Okay, for these institutes, can you give us the breakup?
I will. Regarding which, my lord, it consists of the cost.
May not be available. In fact, it may not be available also, but if it's available, please give us.
Religion-wise may perhaps not be available, but my lord, AIMS,
But if it's available, just give it.
but otherwise, no, AIMS, IIMs, IITs, my lord, your lordships can take judicial note. It is for all spectrums. Now, please see, my lord, what triggered this petition. 3E, volume 3E, page 34, my lords. This was under challenge before the High Court.
The solicitor, could you come to 33?
33. Same 3E.
Same volume. 33. It refers to a letter received from the Assistant Director dated 3rd December 2004.
They have read, my lord, yes. That is based on 81. He writes that now you are a minority institution, which they have read, my lord. That is, my lord, at page. What that
What's the page number of this 312?
I'll just give the page number, my lords. Lordships, may give me a minute.
This letter is the first time they recognize the it is
17 is page 17.
Page of this volume. 17, my lord, of this volume.
Page 17?
3B. 3E, I'm sorry, 3E for
3E, yes.
elephant.
Whereas page 39 may also be read in 3E. Very important.
Correct, you read it. I will again read it. There is no difficulty.
I did not read.
No, it was
I read.
Mr. Dhawan read. Anyway, I'll read it again. So please come to 34 first. Because my learned friend, my lord, said that ultimately after doing all this, what we need, what we are asking for, some reservation. That was the argument, my lord. I am just showing what is that some reservation in an institute where without reservation there is 70 to 80% persons from one particular community. Please see, my lord, page 34, your lordship gets, my lord. So can I read?
Yes.
34, at the foot of the page, my lord. After detailed deliberation, my lords get, my lord Justice,
Yes.
Justice Particular. After detailed deliberation, the council approved the recommendation of the academic council made at its special meeting held on 15 January 2005 regarding reservation of seats for admissions to MD, MS, PG diploma courses in the Faculty of Medicine with minor modifications as mentioned below. 25% students may be admitted from amongst the internal candidates on the basis of All India test, meaning thereby BSc to MSc, MBBS to MD, etc. 50% of seats may be reserved for Muslims of India to be selected on the basis of All India entrance test. So 75% roughly, not for Muslims, because 70 to 80% as on date who are studying are Muslims. That's an admitted position. Mr. Farasat gave those figures. And I can also give those figures. That without reservation also, 70 to 80% are Muslims. So they would go from bachelor's to master's and 50% straight flat reservation for Muslims and open only for 25%. And this is ranking, my lord, one of the finest universities in the country. I have no dispute about it. Apart from, my lord, it being an institution of national importance, I am not taking your lordship's, my lord, through that. But please, my lord, note here, only for my satisfaction, my lord, I have pointed out the debate of the Constituent Assembly when this was declared to be an institution of national importance. I am not, my lord, reading it, but there are good reasons, my lord, they have given. And page 9, para 16 to 21, para 21.
Page 9, paragraph 16 to 22.
Yes,
That's in your written submissions.
my written submissions. But I have quoted, my lord.
Volume?
2B.
Mr. Solicitor, just get the data, because data may be available online, but may not be authentic and accurate. If the government has any data, please give that.
But I will. But possibly, this is my impression, I'm not making a statement. Possibly, now, when I fill up the form for admission, the religion is not
No, in minority institutions, probably it will be there.
minority, yes.
But
Yeah,
the government,
it has to be.
in the other institutes, probably it's not required and may not be in fact mandated, should not be in fact.
Should not be. Like IIT, IIM,
But
other.
otherwise, the government must be having some data, some figures.
If it is, my lord,
Otherwise,
I'll
figures are available
hopefully
online.
place it on record.
Figures are available on the internet, but they may not be
Accurate, correct, my lord. So, my lord, last line, my lord, I'm not reading it, but this article 15, sub-article 5, when was inserted, was put to challenge, and the challenge is negative. My lord, that is the judgment in Pramati, my lord, 2014, volume 8, SCC, page 1. My lord, relevant para is 31 to 34, 31 to 34.
Just repeat the citation.
2014, volume 8, SCC, page 1, relevant para 31 to 34.
That rejected the constitutional challenge.
Constitutional challenge to sub-article 5 of both article 15 and article 16. My submissions are over, my lord. I'm immensely grateful, my lord, very patient hearing.
Thank you.
For a very patient hearing. Obliged to.
Thank you, Mr. Solicitor.
It's okay.
Before Mr. Trivedi begins, may I have your lordship's kind permission to make a mention about this matter?
Sorry?
May I have your lordship's kind permission to make a mention, my lord? Lord,
Who are you appearing for, Mr. Yatendra Singh?
Lord, my briefing counsel in this particular matter has become a judge of the High Court. And then this last month, my lord, due to my health reason, I was not coming. Last week when I came here, the case is here. I want your lordship's kind permission to submit my written submissions. And 10 minutes of your lordship's valuable time, at whatever time your lordship thinks proper, give me just 10 minutes or maybe 7 or 8 minutes.
All right, let's complete the hearings and we see how much time we have left.
Should I upload my written submission, my lord?
Just wait, presently we'll see. Have you filed an intervention? Have you filed?
Lord, my briefing counsel with whom I was appearing, there were parties in the case. He is elevated. I do not have any connection with the AOR, and probably this is the reason it has happened.
Well, let's wait for a little while, and then we can see what ground is covered, and then if there's something else, we'll give you 5 minutes at the end to make your point.
I'll finish within 5 minutes.
Certainly.
Obliged, lords.
What you can do is that you can circulate your written submissions to the other side so they also know what your point is, and then circulate it to the court master in the electronic form. So he'll add it to our submissions. You can circulate it to the nodal council. The nodal council will then put it together. That's better. Yeah, yes, Mr. Dwivedi.
Lord, the first submission which I wish to address is that to be a Muslim is one thing, and to be a minority, Lord, is another thing.
To be a Muslim is one thing, but to be a
Minority.
what do you mean?
For example, if we are in Jammu and Kashmir, Lord, majorities of Muslims are not a minority. It's in that sense, Lord. The question therefore would be either, Lord, we proceed on the basis of the assumption which was made in Aziz Basha that the Muslims in 1920 were a minority and decide whether they're entitled to the benefit of Article 30, or we consider the question actually on facts, not whether they were a minority in 1920, which requires, Lord, first of all, determination of the most vital question, Lord, which somehow has avoided the attention of this court in most matters, whether they were Christian colleges or whether they were Muslim colleges established before independence. This court has proceeded on an assumption that they were a minority. So how do we understand this concept minority? Do we decide this today in a bench of 7 judges when your lordships are sitting? Or we again, my lord, like TMA Pai say, that these questions are left over, my lord, to be decided later? This question was squarely there, my lord, in question 1 and question 3A. But all that TMA Pai decided was that minority will be decided state-wise. But what is this minority, my lord? Is it a numerical question? Does it have a qualitative content? Does it not require that the people who are now claiming to be a minority understood themselves to be a minority at that time? Only then, Lord, this can be proceeded. So either we avoid it, we say that today in India, the Muslims are a minority, and therefore we, Lord, from that we jump to the conclusion that in 1920 also they were a minority.
But nobody has questioned that, Mr. Dwivedi.
No, I am raising this question, Lord, and that is referred. That is referred. The 2 referring orders, if your lordship will look, Lord, this is the question which has not been addressed. volume 3A,
Question which has really been addressed before us is whether they are established and administered by
a minority.
Right.
Therefore, Lord, are the,
But-
were
But
you a
the fact
minority?
that they were, that Muslims
So were you
were
a minority?
the fact that they are a minority today in UP, and that the fact that they were a minority at that relevant point of time, because whether they were a minority or not has to be decided on today's standards.
No, no, no.
There's no different
I'm
standard
sorry,
in
Lord.
1920 as compared to.
That's precisely the point.
Just getting, it's just a question. That's the thought. Before the constitution, adoption of the constitution, we didn't have any concept of minority and majority. Certain rights have been given under the constitution on which there is no issue in terms of the different articles from 25 to 30. Therefore, the determination whether you are a minority or not has to be done on the basis of a set time period, not in the past. When we refer to establishment prior to the constitution, we'll have to go back in the point of time when the institute was established,
Yes.
but not with reference to whether that community was a majority or a minority community at that time, but with reference to who had established.
No, with great respect.
Who is a minority or majority will be decided on the date when the constitution was adopted. Possibly, what argument you are raising in case there is a demographic change, what will be the effect, is a separate issue.
No, well, your lordships have categorically held in number of cases that fundamental rights are not retrospective. So therefore, only question is whether are you entitled to avail the benefit of Article 30 today? In order to do that,
Will it be
in a- in order-
retrospective? Sorry, interjecting, sorry. Will it be retrospective or retroactive then?
whether it is retrospective or retroactive only means, Lord, that the law today takes notice of the facts earlier, that is retroactivity. When the law is retroactive, it doesn't mean it operates from that day, but it takes note of the facts as they existed earlier. So we are on the question of facts, an assessment of whether this community was a minority when it established. If it was not a minority, and if it did not consider itself to be a minority, then, for example, let's take the Christians, Lords. The Christians were the rulers of the time. The British government, which was ruling this country, was a Christian government. And the missionaries, Lord, were brought in this country with a particular purpose, as an arm of imperial rule. And being that, Lord, under the charters of 1813, 1833, the English Education Act 1945, the Woods Dispatch of 1954, and the Hunter Commission and all these, Lord, commissions were really meant to provide an opportunity to the missionaries to establish the college, to create, Lord, people who were not fair like them, but they thought and whose tastes were like them. That was the objective. That is the great minute of Macaulay. Now, institutions which are established by missionaries to evangelize, to convert, to make Indians like British, and they were given grant of land which was occupied by them. Now, are we going, Lord, is this constitutional intent that Article 30 is to be given a benefit to these kind of institutions which were meant for a colonization purpose, for imperial rule purpose?
But that's not the character of AMU. Why should we decide that question?
Now, AMU question, therefore, we need to decide the question with, I'm coming to the Muslim minority.
What was the political unit within which AMU was then established? There was no state of Uttar
Whether
Pradesh at that time.
Whether you take it as a state unit or national unit, for my submission, may not be very pertinent, Lord. But we have to take British India because Indian states were outside. Or we take the Northwest Province or subsequently the United Province as it was called. What was the status, Lord, and position of the Muslims then? Could it be said in 1920 that they were a minority? The rule was of the Christian British rule, who were less than the Muslims. Neither the Hindus nor the Muslims, we were both subjects. We were not even citizens of Britain. There was no concept of citizenship, even that this court has said in Patro's case. So therefore, there is minority rule in India. That's the unfortunate part, not only in India, but in so many other parts of the globe, where the British imperialism was ruling. The position was that a handful of people were ruling over India for the last several hundred years. So are we to say, my lord, that the Mughals were in minority, the British imperialists were in minority? This will be something very, very strange, my lord, that after being a republic, we are trying to bestow a characteristic, a status of minority on those who were not a minority. The Muslims were more than the rulers. The Christians who were ruling through the Governor General and the HMG, His Majesty's government, they were smaller in number than the Muslims. Therefore, I request your lordships to first of all, instead of again avoiding to go into this question, please decide this question. It's too long, my lord, for 75 years and more, my lord, we have been evading this question. And we just assume and we stamp them as a minority institution and confer the benefit of Article 30 to them. According to me, there are three aspects, my lord, of this minority. And this is a question, my lord, which has been referred to your lordships. The first referring order says, Lord, decide the essential conditions or ingredients of the minority institution may be decided once for all. That is volume 3A, page 209. In my additional written note, Lord, which is 2J, volume 2J, in first paragraph, I have extracted this portion. Volume 2J. It is all right for the petitioners to proceed on the assumption, my lord, as in Aziz Basha, but what is referred to your lordship is decide essential conditions or ingredients of the minority institution, which may be decided once for all. And the second referring order refers to TMA Pi, and that's one of the reasons for referring the entire matter to your lordships. That is question 3A, which is framed in that case, TMA Pi. What are the indicia for treating an educational institution as minority educational institution? Would an institution be regarded as minority educational institution because it was established by persons belonging to a religious or linguistic minority, or it's being administered by a person belonging to a religious or linguistic minority? So first of all, we have to decide this question. And I am placing three characteristics, which are absolutely essential. Why was Article 30 needed as a safeguard or protection? Because of the fear of domination by majority. So it's a protective, it's a safeguard. Number two, Article 30, Lord, will walk hand in hand with Article 29(1). It can walk separately also. It's up to the religious minority concerned to decide how far they wish to go. These are not simple provisions of reservation. The object is to enable them to maintain their character as a religious minority. And in that respect, Shazan was right. To reduce it to reservation, the Lord is to completely kill this Article 30 and equate it with 16 and 14 and 15. So being a protective safeguard, Lord, what follows is there is an idea of domination inbuilt in this. The fear of the minority, that is character, that is culture, that is language, that is script, may be overridden and demolished by the majority. So therefore, a minority is that which is less in number than the ruling majority.
How will you apply this test?
This
In
test will apply.
mathematical
Who was ruling at that point of time? Were you less than them or more than them?
That means ascertaining.
Ascertaining the numerical test. I call this a numerical test. If the Christians are ruling, you aggregate all the Christians, aggregate all the Muslims of various sects, and decide whether they are less in number or not. That's a numerical test in my humble submission. The second test is a test of non-dominance. So if that particular community, though being less in numerical, in numbers, if it is a ruling power, then it cannot be a minority. Less in number and non-dominant. Because that's the correct idea underlying Article 30. If you are ruling, then you don't need a safeguard. You don't need to protect yourself. That's the qualitative test. And the third is that the community which is claiming that status should be considering itself to be a minority. The group which is founding the institution should be considering itself to be a minority.
Repeat the third test, Mr. TAD.
The third test is that the community which is claiming to have established the institution should be considering itself to be a minority.
The founders should consider themselves to be a minority.
Minority, yes. If they reject that claim and seek some other status, without, my lord, these three factors being considered as on 1920, we will be looking at history in a blinkered way, in a partial way.
On that aspect, you see, the third aspect, leaving the third aspect slightly aside, when we refer to a statute being retroactive, we'll have to and also take into account what is the object and purpose of the Article 30, which you have yourself articulated. We go back in point of time to find out who are the person who has established that institution. But the question whether they were in minority or not at that time may not be relevant. What will be relevant is whether on the date when the issue is being examined, whether they are minority or not.
No, the issue is they have a right to establish. Today, no dispute.
What you are saying is we'll have to go back in point of time and examine whether when it was established, it could be treated as a minority institution, because there was no concept
we are going back. We are considering who founded in 1872 the primary school, who founded it, the secondary school, who founded MAO,
what is the parameter?
who contributed. We are going back.
We are going back.
But we want to stop, and we don't want to consider the character of this group at that point of time, the character which this group was claiming for itself.
But Mr. Dwivedi, apply your three tests. Your first test is minority has to be less in number than the ruling majority.
Yes.
Now, going by that test, the ruling majority, as you rightly said, was the imperial government. Therefore, those people who founded were certainly less in number.
Those who were ruling were a ruling minority.
Therefore, there was no minority.
Right, but
And Muslims were more than the Christians at that time.
that can never be the test, Mr.
So, Lord, therefore, that's the whole point. We want to consider everything in history, but not that part of the history, Lord, which is absolutely relevant, Lord, to the establishment.
Because we were ruled by colonial power, which was hopelessly, of course, it was a minority, but that's the whole point. That was the whole that was the whole genesis of the freedom movement. But to therefore say that any claim for minority status has to be rejected because those who were ruling were in any case a minuscule minority.
The reason is this.
Can we now deny minority status because of the fact that, well, the rulers were in any case in a minority?
The whole problem is arising because the Constitution has given a right to the present minorities, the Muslims, the Christians, and whoever else is involved, to establish and administer. This is a right which is given by the Constitution and operates ex post facto. But by judgment, Lord, we have tried to accommodate and extend it to a scenario which existed prior to the Constitution.
So therefore, to see whether you are entitled to a constitutional right, you look at the status or position as on the birth of the Constitution.
And even afterwards.
Right, and thereafter. Now, according to you, you have to go all the way back at the point of the birth of the institution.
So either we go or we don't go. If we don't have to.
No, but if you do, the test cannot be the numerical majority in relation to the rulers at that time.
Has to be, my lords. Otherwise, if you are not a minority, otherwise, what are we doing? What are we doing? We are taking note of, we don't want to take note of the act. Then don't look into the history at all. Look at the act. Act says it has been established, my lord, by the Governor General in Council, the end of the matter.
So prior to independence, then according to you, there'll be no minority at all.
There was no minority institution at that time. We were all subjects. The Hindus and Muslims were at par. I was as subject as they were.
Is the sequitur that any institution established prior to independence would not be a minority institution?
Yes, that's my humble submission, and this court has committed an error in my humble submission, with deference, by not examining this aspect, by simply assuming in every case that. So what is the result?
When the Constitution says in Article 30, all minorities, either linguistic or religious.
So established, today nobody says.
But when it says all minorities, it certainly looks at the position, the sociological position and the historical position prior to the birth of the Constitution.
It cannot be, my lords. All minorities
are not created for the first time post 1950.
The question which I am posing for your lordship's kind consideration is the Constitution attempting to
How did they become minority?
force us to imagine that India was actually a republic in 1920? Or what are we trying to do by taking it backwards? We are caught in a.
Of course, it's all. How many judges? 9?
6 or 7 to study.
Is the consequence of this assumption is not, we are actually trying to take the Constitution and applying it retrospectively. We may call it retroactive, or we are applying the principles of it backwards. No, we are actually giving.
Not like that. We also have to understand the historical perspective of the Constitution. Why did the Constitution introduce certain safeguards? It was a safeguard intended to hold out an assurance to communities which were otherwise joining the mainstream of the Constitution that you will be protected. One article of that protection was your right to establish and administer educational institutions of your choice.
No problem, my lords. After 1950, nobody is contesting. I am also not contesting that all these people who are now actually a minority, they are entitled to establish, and they are establishing. Nobody is preventing them from doing so. The problem is arising only when we are taking these principles back, my lords, and backwards, and not for a few years, but several decades. and then saying, because most of the colleges established by Christian missionaries are between 1850 and 1900, so we take it back 100 years and say that even though you established this institution as a ruler, as governing arm of,
Trivedi, there can be number of arguments, counter arguments, etc. Why can't we have more institutions being established of equal status and character or equal excellence? There can be number of arguments on either way. That will not. Real issue is did the Constitution in Article 30 say? The Constitution was certainly aware that there are minorities in India. There is some safeguard to be, in spite of the partition of India being on religious line, they said we will adopt and give certain safeguard to the minorities. That's the commitment of the Constitution. And on interpreting that, if we accept your argument is, all institutions which had come up prior to 1950 will no longer, there is no need to examine whether they are minority institution or not.
that is correct. That's what I'm submitting with, and this is something which your lordships have not debated and considered and decided.
Mullahs, in Kerala Education Bill, I'll just read, there is no reason why the benefit of Article 30, Sub-Article 1 should be limited only to educational institutions established after the commencement of the Constitution. The language employed in Article 30, Sub-Article 1 is wide enough to cover both pre-Constitution and post-Constitution institutions. 7 judges of this court. I have to revert it to 9.
No, it doesn't matter. 7, 9, and 11. Well, that's for lordships to decide. But the question is, what is Henry Kerala saying? Kerala is not saying that they were considering a presidential reference. So, supposing before the Constitution, the Parsis have established. They are numerically small. They were a minority. They were less than the Christian ruling powers. They will be entitled. So it's not saying don't examine whether you were a minority then or not. And that is the problem that there are not really Kerala. Other cases also assume, in Patro it's assumed that they are in minority. It would be a very amazing conclusion that Christians who were ruling at that point of time. Today, yes, they are minority. But at that point of time, you ruled over us, you were evangelizing, your mission was that, and we are ready to give a stamp of minority and the benefit of Article 30 to them. So those missionaries who came here and to do evangelization, to act as an arm of colonial rule, with great respect, to confer upon them the status of minority, will be completely, that's not the, no provision in the Constitution, has any intent of being retroactive in this sense. They were the arrowheads of Western cultural imperialism in India. And we are saying that you are minority, you get the benefit of Article 30. So we forget, we take note only of the fact that Mr. Syed Ahmad Khan was inspired. He wanted to attract Muslim youth to Western education. So he set up a primary school. And he set up the primary school in 1872, even while being in the employment of the East India Company and thereafter under the British government. He retired from the British government service in 1878. So as an employee of the British government, he establishes a primary school, then secondary school, and then MAO, gets a grant from the British government, and then he becomes an imperial council member for 8 years. And then he becomes a member of the council of the Northwest province. So what he is acting as an arm of the government. Look, British government had certain specific intent with regard to Muslims and Hindus. So again, Lord, we have to forget all those things. He was an arm. Whilst being a government servant, he is establishing this. With the aid of government grant, with the aid of government money, with the aid of money which is coming from the Nawabs who are of the Indian state, which is also a government. Where is the private community sprinkling dollars maybe here in a small amount of collection? Everything was because of that. Viceroy Leighton will not come all over Mulot to inaugurate MAO merely because he was an employee of the government, a sub-judge at that time, and therefore he comes there with their own objectives, imperialist objectives. These schools and colleges, the group headed by Mr. Syed Ahmad Khan by itself neither had the right to establish institution, nor they had the power to establish the institution, nor they had the capacity to establish it. Everything flowed in from the Governor General's government and from the provincial government. The 30 lakhs money came from Nizam. He is a ruler of the Indian state. But we can start looking at his face and his belief and then say he is a Muslim. But he is a ruler, monarch. Maharaja Patiala, he was a monarch. Maharaja Vijayanagram, he was a monarch. They are all made patrons, lords, in the AMU Act. Where from the fund is coming? Not from the community, but from those who are governing the British government itself and the loyal princes. Now we can say we will not look at the loyal princes, but the Chamber of Commerce Princes, which was constituted in 1923. We can also overlook that the princes were not the breakers of storm which comes in India. The freedom struggle, every force which was against the freedom struggle, to all of them, we are very grateful and we confer the status of minority. So it's not established by them. They don't have the capacity. They could not run it. Yes, they wanted a university to request and to negotiate non-essential terms and to be members of court. If that is sufficient to establish, I submit it is neither founding nor establishing. Now, what was the status which Syed Ahmad Khan was seeking? I have annexed his own letter. Kindly see my written submission notes at volume 2H. Page 18. They considered themselves to be a separate nation, not a minority. And he is the founding father of this. Kindly come to page 18, the footnote where the letters was, which is the speeches which he gave in 87, 88. Your Lordships have it? We ought to consider carefully our own circumstances and the circumstances of government. If the government entertains unfavorable sentiments towards our community, then I say with utmost force that these sentiments are entirely wrong. At the same time, if we are just, we must admit that such sentiments would be by no means unnatural. I repeat it, if government entertains these bad intentions, it is a sign of incompetence and folly. But I say this, we ought to consider whether government can entertain such thoughts or not. Has she any excuse for such suspicions or not? I reply that she certainly has. Think for a moment who you are. What is this nation of ours? We are those who ruled India for 600 or 700 years. From our hands in the country was taken by government into its own. Is it not natural then for the government to entertain such thoughts? Is government so foolish as to suppose that in 70 years we have forgotten all our grandeur and our empire? Although, should government entertain such notions, she is certainly wrong. Yet we must remember, she has ample excuse. We do live on fish, nor we are afraid of using a knife and fork lest we should cut our fingers. Our nation is of the blood of those who made not only Arabia but Asia and Europe to tremble. It is our nation which conquered with its sword the whole of India, although its people were all of one religion. I say again that if government entertains suspicions of us, it is wrong, but do her the justice and admit that there is reasonable ground for such suspicion. Can a wise ruler forget what the state of things was so short a time ago? He can never forget it. If then Mohammedans also join the monstrous and unreasonable schemes which are impossible of fulfillment and which are disastrous for the country and for our nation, what will be the result? If the government be wise and Lord Dufferin be a capable viceroy, then he will realize that a Mohammedan agitation is not the same as a Bengali agitation, and he will be bound to apply an adequate remedy. If I were viceroy and my nation took part in this affair, I would first of all drop down on them. In time, Lord Ripon, I happened to be a member of the council. Lord Ripon had a very good heart and kind disposition and a very qualification for a governor. But unfortunately, his hand was weak. His ideas were radical. At that time, the local board and municipality bills were brought forward, and the intention of them was that everybody should be appointed by election. Gentlemen, I'm not a conservative, I'm a liberal. But to forget the prosperity of one's nation is not a sign of wisdom. The only person who was opposed to the system of election was myself. If I'm not bragging too much, I may, I think, say that it was on account of my speech that Lord Ripon changed his opinion and made 1/3 of the members appointed and 2/3 elected. Now just consider the result of election. In no town are Hindus and Mohammedans equal. Can the Mohammedans suppress the Hindus and become the masters of our self-government? In Calcutta, an old bearded Mohammedan of noble family met me and said that a terrible one of whom calamity has befallen them. In his town, there were 18 elected members, not one of whom was a Mohammedan, all were Hindus. Now he wanted government to appoint some Mohammedan and he hoped government would appoint himself. This is the state of things in all cities. In ALIGARH also, there are not special rule. It would be impossible for any Mohammedan except my friend so-and-so to be elected. And at last, he too would have to rely on being appointed by government. Then how can we walk along a road for which neither we nor the country is prepared? Kindly turn over leaf at the bottom. This is second speech extract. No, the letters are annexed. After this long preface, I wish to explain what method my nation, rather whole country of this country, ought to pursue in political matters. I will treat in regular sequence of the political questions of India so that you may have full opportunity of giving your attention to them. The first of all is this: in whose hand shall the administration and the empire of India rest? Now suppose that all English and the whole English army were to leave India, taking with them all their cannon and their splendid weapons and everything. Then who would be rulers of India? It is possible that under these circumstances, two nations, the Mohammedans and the Hindus, could sit on the same throne and remain equal in power. Most certainly not. It is necessary that one of them should conquer the other and thrust it down. To hope that both could remain equal is to desire the impossible and the inconceivable. At the same time, you must remember that although the number of Mohammedan is less than that of Hindus, and although they contain a far fewer people who have received a high English education. Yet, they must not be thought insignificant or weak. Probably they would be by themselves enough to maintain their own position. But suppose they were not, then our Mussalman brothers, the Pathans, and the come out as a swarm of locusts from the mountain valleys and make rivers of blood to flow from their frontier in the north to the extreme end of Bengal. This thing, who after the departure of English would be conquerors, would rest on the will of God. But until one nation had conquered the other and made it obedient, peace could not reign in the land. This conclusion is based on proof so absolute that no one can deny it. So therefore, my Lord, this is what they thought of themselves. The group, I'm limiting myself to the group which is said to be pioneering, my Lord, the establishment of institution. I'm not talking about the entirety of the Muslims. They were nationalists also. There were people who did not believe in the two-nation theory also. But here is the moving spirit who never thought that he is a minority. His spirit was that we are nation. His spirit was that we have to be loyal to the British. And even the British thought like that. They also said India is a multinational. So this concept of minority was not there. Should we then, my Lord, ignore all these important aspects of history? At no point of time before his death in 1898, he changed his views. And it is this inspiration which led to the grant of separate electorates in 1906 and the division of Bengal in 1905, which led to the freedom struggle, my Lords. And why did this movement for University of BHU and this start, my Lord, in 1915 and 1920? Both cases, the request was made in 1911. That's the record on this, Mr. Shafi's speech itself. The request was made in 1911 when the Prince of Wales was visiting India, when India, my Lord, the capital was being shifted to Delhi, and Bengal was reunited. That's why in the speech, my Lord, all this is coming. The rise of and the renaissance of Bengal was behind this. So in 1911 it started. They made a request. There were negotiations begun. And at that time, BHU accepted the terms and conditions, the format, the scheme of administration, and therefore BHU Act was made in 1915. Now they were resisting, not accepting. Ultimately, they fell in line. All that has been shown to your Lordships. So the Governor General says, you accept the BHU pattern. That's the command. There was no choice to them. Plus, kindly bear in mind one thing, that the Governor General was the supreme power. He could do whatever it wanted. It is one thing to say that the university is established by the Muslims. It is another thing to say that the university was established by the Governor General in Council for the Muslims. There is a distinction between by and for. Even today, my Lord, the government, the parliament can pass an act saying that for tribals, we are establishing a university. The tribals will be member of the court. So the fact that it is meant for tribals will not mean, my Lord, that it has been established by tribals. The tribals may go from Jharkhand, my Lord, and Chhattisgarh and the northeast, and they may request the government of India to give them a university. They are not getting enough educated students from their midst. And acceding to the request, the parliament passes an act saying that this will be a tribal university. So it's not established by tribals. Nothing prevents the Governor General Council to form a university, to establish a university, to found a university for a particular denomination, community, tribals, scheduled caste, whomsoever they wanted. They had absolute power. But what they do in this case, from MAO college to the university is a change of status and level of education. I have, Lords, in my written submission, Your Lordship will, because of time, Lords, I will not be reading through all the paragraphs. I have brought out, Lord, from the basis of Wood's dispatch of 1954 and the Hunter Commission, because the Hunter Commission was not concerned with the university. It is the Wood's dispatch, Lord, which is the foundation. Wood's dispatch 1954, which is on record, placed by the government, which is the starting point of universities in India. First, Lord, in 1857, 3 universities: Calcutta, Bombay, Madras. All 3 established by Act, initially, Lord, as an examining university, then in 1860, Lord, to award degrees and teaching also. In 1882 comes the Lahore University in Punjab. And in 1887, the Allahabad University. In 1904, after a commission's report in 1902, in 1904, the Indian Universities Act was enacted, and all its provisions were read into the act of the 5 universities which were existing. It says so in section 2 that all the provisions of this should be read into that. It provided a particular structure of administration. And the format was based on the London University. Now, what is the importance of this, Manoj? The importance is that whilst the British government allowed private persons to establish schools and colleges, it kept the power to establish a university to itself. There is no British policy shown to your lordships, and based on these policies which we have placed on record, there is no British policy which enabled private persons to establish university. That is the reason why the Hindus and Muslims had to make a request to the Governor General in Council, for they alone had the power. In fact, in the Lahore University, I have mentioned, there was one gentleman, he was a Christian, and he led a movement, and he made a request to the Governor General in Council to establish the Lahore University. So the fact that somebody is behind the move, behind the request, or contributing some little thing, some existing property, that is not founding, that is not establishment. In my submission, founding and establishment are synonymous. It can't be founding that I have gone to the Governor General in Council. So you say you have not established, but you have found. Mr. Sirvai is not right. Great respects to the eminent jurist, and many a times the lordships have accepted what his criticism, many a times the lordships have not. In the context of Article 30, founding and establishment was bringing into existence is one and the same thing. Founding is not making requests. Founding is not going up to the Governor General and meeting some officials and negotiating something non-essential. Supposing I go to the Governor General and say, I have some little property of 5 acres, I can't establish university. You please bring in more land, etc. You have enough funds, so you can establish it. Give me some role in this. Is that founding? Is that establishment? So therefore, let us not quibble and semantics. Contextually, it can mean nothing else. Founding is nothing short of bringing the infrastructure, bringing the funds, bringing the faculties, and constituting the framework, the most important, constituting the scheme and framework of the university's functioning. Today, minority institutions are being established. It is the societies and the companies which are formed which present their own scheme of administration. They appoint the chancellors, the visitors. So the scheme is formed by them.
But Mr. Dwivedi, just as we are concluding, we may reflect on it. Your position, therefore, is at variance with what the Solicitor General argued. Because the Solicitor General argued that there was no prohibition on any private individual establishing a university in British times. If you wanted to do it, you would not have recognition for your degrees. Your position is that, look, there was no question of any private person establishing a university. It had to be done by or under an
just a little qualification.
Charter of the imperial power.
Yes, just a little qualification that this is in the context of universities whose qualifications and degrees are recognized. Private universities, you can go and establish, your degrees will not be recognized. I am limiting my submission to universities whose degrees are recognized, who are imparting Western education, Western science, liberal arts. If you are having a Sanskrit university of your own, private, that's a different thing. That we had from long back, Nalanda universities and all that. University is not a concept which is emerging for the first time, but that's what they wanted. Solicitor also said the same thing. He was referring to Vishwa Bharati and other Kashi Vidyapeeth and Jamia and so on. So that's there you don't require the Governor General. And there was no law which said that you can't use the word university, like today. But if you wanted to have a university whose degrees are recognized, then only Governor General could do it. There was no policy. University as a subject was expressly excluded from the Hunter Commission. Kindly advert to the recommendations of the Hunter Commission, it was excluded. So they went to the Governor General because they had no adequate land, they didn't have adequate funds, no capacity, and they knew that it can't be established unless Governor General creates it.
Come back after lunch. 40 minutes.